Welcome to the first in a series of webinars brought to you by PKF Texas. We were pleased to welcome Kristin Ryan of PKF Texas, Carl Gillette of Aon, and Brian Giovannini of Haynes and Boone to discuss retirement plans, navigating recent law changes, and using them to your advantage. This presentation was recorded live on June 25th, 2020 as a Zoom webinar. All information was accurate and current at that time. Those viewing this recording now are not eligible to receive CPE credit from PKF Texas. If you have questions regarding this webinar or future PKF Texas webinars, please feel free to email us at jlemansky@pkftexas.com and we will get back to you as soon as possible. All right, good morning everyone I'm not sure if you're in Houston, but if you are, it's definitely wet and rainy. So thank you for joining our webinar, Retirement Plans, Navigating Recent Law Changes and Using Them to Your Advantage. We really appreciate you taking the time today to spend some time with us. Just a few housekeeping things. Everyone who attends this live webinar today will receive CPE credit administered by PKF Texas. In addition to attendance, you will also need to answer one of the polling questions the panelists have prepared today in order to be eligible for CPE. The panelists are happy to answer questions throughout the presentation in addition to the dedicated Q&A time at the end. So please submit your question through the Q&A button at the bottom of your screen, and also be sure to indicate who you would like to answer your question so that we can direct it to them. I'm going to introduce our panelists now. Kristin Ryan is a senior manager on our audit team here at PKF Texas. She's been with the firm for over 12 years, and she leads our employee benefit plan audit and advisory practice with a growth-minded effort. She has extensive experience focused on employee benefit plan audits, including primarily 401k and pension plans. Up next, we've got Brian Giovannini with Haynes and Boone. He serves as an advisor and benefits counsel to a diverse group of clients, from local governments to Fortune Global 500 corporations. Using his technical knowledge and analytical skills, he assists in numerous legal issues affecting the development and operation of pension plans and executive compensation plans and agreements. And then rounding out our panel today, we've got Carl Gillette, an associate partner and consulting actuary in the Retirement Solutions Group at Aon. He supports his clients with the design, financing, and accounting, compliance, and administration of retirement programs. And Kristin, we'll have you take it away.
Great, thanks, Jen. Glad to have everybody here. Appreciate you taking the time. As Jen said, we're excited to be here, and we're hoping, you've heard about COVID, but we're hoping to shed kind of a different light here with all three of us and our different perspectives. So hope that you get some good information today. So what are some of the things we're going to see with COVID, or we're already seeing as a result? Some of the things that have come to mind as we've been discussing the topic are plan terminations and terminations. So hopefully you're not experiencing this, but if you are, we just wanted to discuss briefly. A partial plan termination typically means that you've laid off about 20% of your workforce. And one of the kind of caveats to this now is that furloughs have occurred a lot in this and what we're going through right now. So furloughs could count toward that calculation. So that's just something to keep in mind. It is a facts and circumstances based determination. So a lot of times there is ERISA attorney involvement in determining whether there's a partial plan termination. And then for most plans, this is going to trigger full vesting of participant balances. Now, if you're a traditional safe harbor, those balances are likely already vested, but just to throw that out there as a possibility, that's usually the impact of the partial plan termination. And then a termination obviously is different. The plan's going away, and we just want to mention that not only because there's certain requirements that go along with that, but also there's liquidation basis accounting that needs to be considered when preparing the financials for the plan. And then some other things we're seeing already, or probably going to continue to see, is suspension of employer contributions. And when it comes to that, it's just important to know that to consider the types of contributions that you have in the plan and make sure that the proper plan amendments and participant notices are occurring. We are likely going to see increased loan and distribution activity, changes in savings rates, ADP and ACP testing implications, market declines, of course, and going concern considerations, and significant plan amendments. So we'll move on to laws and regulation updates. So as you all know, I'm sure by now, just want to reiterate, the ones that primarily relate to the 2020 plan year, although the effective dates do vary, is of course the CARES Act and the SECURE Act, which we're going to go into in detail today from all perspectives. The dates signed are included on the slide. And the end of year rule, we just want to mention because most of the time this is what determines when you need to make your amendments. So the amendment usually needs to happen by the end of the plan year in which the change was made, but there has been an extension for CARES and SECURE through the end of 2022 for those amendments to take place. And then primarily relating to the 2019 plan year, so as auditors, we're looking back at that year right now and doing those audits. Some of the things that came up last year, but just as a reminder, if there are amendments that are going into effect during 19, these would be related to the Budget Act, which was a big one that impacted hardships. And student loan benefits, just wanted to mention because that may be something that we start seeing more in plans as an option where employers may make non-elective contributions to an employee based on the amount of the student loan repayments that they have. And just as everybody probably knows as well, but a reminder that there has not been an extension for either the Form 5500 or the PBGC filing beyond 10/15 for calendar year plans. So I will turn it over to Brian to get into the meat of the CARES Act.
Thanks, Kristin. So the first thing we're going to talk about with respect to the CARES Act are CARES Act distributions are called coronavirus-related distributions. And what it is, it's a new feature that plan sponsors can add to their 401k plans and other DC retirement plans. And it allows for a withdrawal of up to $100,000 through December 30th of this year. And keep in mind that that's December 30th is the last day that somebody could take a distribution. And so who is eligible to take a coronavirus-related distribution? Well, that would have to be somebody who's a qualified individual. So it's an individual who either that individual or their spouse or the dependent is diagnosed with either SARS-CoV-2 virus or with the COVID-19 disease on a test approved by the CDC. The individual, another way that somebody could qualify and be a qualified individual and eligible to take a coronavirus-related distribution is if that person or their spouse or a member of their household, and this could include like an adult child who's living at home with them, experiences an adverse financial consequence as a result of one of several different factors. They could experience this adverse financial consequence as a result of being quarantined, furloughed, or laid off, having work hours reduced due to COVID-19, being unable to work or due to a lack of child care because of COVID-19, closing or reducing the hours of business that is owned or operated by that individual due to COVID-19, or they have a reduction in pay or self-employment income due to COVID-19, or they have a job offer rescinded or a start date for a job delayed due to COVID-19, or any other future factors that the Secretary of Treasury might decide to include. So let's talk a little bit about this coronavirus-related distribution. What are some of the benefits versus other types of distributions that an employee could take from their 401k plan? Well, the first one is that the limit is up to $100,000. So this is a pretty substantial distribution that they can take, and they can take it in service, and they can recognize the income that they receive through this distribution over 3 years. So the participant gets to make an election. They say, hey, I want to take this coronavirus-related distribution, and then they can choose. Either I have it treated as taxable income in the year that I take it, which is 2020, or I can spread it out over 2020, 2021, and 2022 in 3 equal portions. It's important to note that although an employee can take more than one coronavirus-related distribution, the sum total amount can only be $100,000 in the aggregate. And if they take multiple distributions and they decide to treat any of the distributions ratably over 3 years, they would have to do that with all of the distributions. So you can't pick and choose and take a portion and treat it as income solely in 2020, and then with the rest of your coronavirus-related distributions, treat them as income over 3 years. Another benefit of the coronavirus-related distribution is that the employee can pay it back. So they can pay it back into the same plan, or they can pay it back into an IRA or another qualified plan. They have to do this within 3 years, and then what they do is they get a credit back for the taxes that were assessed on that. And it's treated as a qualified rollover contribution when it's paid back into a plan or IRA. And the third big benefit of this is that when they take this money out, there's no early withdrawal penalty. So if you have an employee who's subject, who qualifies as qualified individual, they want to take this distribution, but they're under age 59 and a half, they're not going to get tagged with that 10% penalty if they take the distribution. So from an employer standpoint, what do you need to know? Do you have to add these to your plan? No, you don't. It's completely optional. So if you want to add coronavirus-related distributions, you can offer that to your employees and tell them about it. If you want, you can offer a lesser benefit. You don't have to have the limit extended all the way to 100,000. You can cap it at a lower rate. You don't necessarily have to offer them the repayment option back into your plan either. So if your plan doesn't allow for rollover contributions, you don't have to add it just because you add a coronavirus-related distribution. Similarly, if your plan does allow rollover distributions, but you don't want to have to deal with the administrative hassle of determining whether these repayments qualify as qualified repayments of CRDs, you can carve them out from your rollover repayments, that are permissible into the plan. Now, how do you know if your employee is a qualified individual? Well, there's good news. You can rely on their self-certification. So all the employee has to do is certify to you that they satisfy one or more of the requirements. And the IRS has made this very easy because there's a self-certification form that they provided in IRS Notice 2020-50. It's a template form. You can use it and you can give it to your employees. Now, what if you want to offer coronavirus-related distributions, but you don't want to make it available to just anybody who qualifies as a qualified individual? Let's say you want to limit it to just a subcategory of those qualified individuals, such as individuals who actually suffer from the coronavirus or COVID-19, and maybe not individuals who have a separate business that they're running on the side and they had to shut down that business due to COVID-19. Well, you can also do that. You can limit the factors for which you will allow an employee to take a coronavirus-related distribution. Now, from the employee standpoint, if they take a distribution and it's not designated as a coronavirus-related distribution because maybe your plan doesn't permit those, they can always later on, when they're filing their taxes, if they otherwise would qualify, they can treat a different type of distribution as a CRD. So for example, if they take a hardship withdrawal, then for tax purposes later on, they can say, hey, this was a CRD because I qualified for CRDs. And the last thing I wanted to mention on this is, even if you don't offer coronavirus-related distributions, the final Treasury regulations last year did provide for a new type of hardship withdrawal, and that's a hardship withdrawal for expenses and losses incurred on account of a FEMA-related disaster. So if you don't offer these coronavirus-related distributions, you could offer these additional hardship withdrawals to your employees. Now, I know Carl's going to talk more about loans that are provided on the next slide, but I just wanted to go through real quick some considerations that an employee might take into mind when they're deciding whether to take a coronavirus-related distribution versus one of these new qualified loans that are going to be available. These are enhanced loans for qualified individuals. One is that if you're taking a coronavirus-related distribution and you pay it back, you get relief on your federal income tax, but there's no clear relief necessarily on state income tax. So if you're in a state that has a state income tax and an employee takes a distribution and pays state income tax on it, it's not necessarily the case that when they pay it back, they're going to get relief or credit on their state income tax. That's going to depend on a state-by-state basis on whatever state laws are passed to handle these distributions. The distribution is considered to be income. So if somebody's trying to decide, hey, I'm planning on paying this back, do I want to take a distribution or do I want to take a loan? Even though they pay it back, if it's considered to be income right away, it might offset any disability payments that they're receiving or unemployment payments. It might cause them to go over the threshold for eligibility for those. So they need to take that into consideration when taking a distribution as well. And the third thing to take into mind is that when you take a coronavirus-related distribution, that's going to be treated as a hardship distribution for Section 409A purposes if you have a non-qualified plan. So if you have an employee who's participating in your 401k plan, also participating in a qualified plan, and they take a coronavirus-related distribution, that may impact their participation in the non-qualified plan. If the non-qualified plan says that future deferrals are stopped if an employee takes a hardship distribution in the 401k plan, then that would actually trigger that, and it would cause them to stop making their elective deferrals into the non-qualified plan for that year. Let me turn it over to Carl, and he's going to talk a little bit about the waivers of required minimum distributions for this year.
All right. Yes, thanks, Brian. So RMDs, required minimum distributions, as you can see here in the second to last bullet point, are not required in 2020 for defined contribution plans or IRAs. So what does this mean? So, it means that participants do not have to take any distributions during 2020 from their defined contribution plans or IRAs. Or if the participant has taken a distribution in 2020, part or all of that distribution can be rolled over into a qualified retirement plan or an IRA on or before the later of August 31st of this year, or 60 days following the date of the distribution. So the one key thing to understand about this is that it also includes RMDs for participants who turned 70.5 in 2019, whose first RMD date would have been April 1st of 2020. So in some instances, these participants would have already taken their RMD, their first RMD in 2019. So they don't get any relief. But to the extent that these participants waited until 2020 on or before April 1st of 2020 to take that first RMD, they no longer have to take that first RMD either. So they're getting relief from both that RMD for the year they turned 70.5, 2019, as well as their RMD that they would have to take by the end of this year for 2020. So a little bit of a double relief for those folks. Also wanted to point out that this RMD relief, it only applies for defined contribution plans and IRAs. So again, this does not apply for defined benefit plans, or as you often referred to as just regular old pension plans. Another comment here before we leave the slide, move on to loans, is that the changes to the tax treatment of distributions that are paid out in 2020 is mandatory. However, it'll be the plan provisions that determine if payments are made or not. So amendments need to be made to the extent that payments are going to be paid out, or distributions will be made out if you do not want those to be paid out, or vice versa. If the distribution wasn't automatically going to be paid because it's not technically an RMD, if you want that still to be paid, then amendment would need to be made to that effect as well. In regarding payments that are made in 2020, normally 20% mandatory tax withholding would apply. However, to the extent that the payment would have been the amount necessary to satisfy the RMD for 2020, it's now going to be subject to 10% optional withholding rather than 20% mandatory withholding. And so again, as Brian pointed out, you know, the CRDs are optional. However, the RMD tax treatment is mandatory. It's not optional. So you cannot pay out the RMD and have it subject to 20% mandatory withholding. All right, so with that, we'll move over to the next page, plan loans. So on plan loans, what did the CARES Act do? Well, the CARES Act provided temporary relief or temporary option for plan sponsors to increase the maximum loan to the lesser of $100,000 or 100% of the vested account balance. So previously, the maximums were $50,000 or 50% of the vested account balance. So this temporary option is only for new loans issued between March 27th and September 23rd, 2020. You'll see on the slide there, we show September 22nd. That actually should say September 23rd. So that's one area of relief provided by the CARES Act. And again, this increase in these loan maximums, this is optional. Another area of relief, and again, temporary relief that offered by the CARES Act with respect to loans is in regards to loan repayments. So any loan repayment that was previously scheduled to be due between March 27th and December 31st now does not have to be repaid during that time period. And so IRS Notice 2020-50, provides a safe harbor for how to adjust the loan repayment schedule. So it gets a little bit complex, but the key items to note are no loan repayments are required after March 27th through December 31st of 2020, and the original loan term can be extended by up to 1 year. So if the loan was set to be fully paid back by January 1st of 2025, now it can be paid back by January 1st of 2026. And again, more details about how the loan would be repaid can be found in IRS Notice 2020-50, which provides a safe harbor to follow. And again, as we saw with CRDs, the CARES Act loan provisions are optional and plan amendments are required if plan sponsors want to implement them. All right, so we'll move next to plan sponsor considerations. So while we have discussed the ability to delay, defer, suspend various items on the prior two slides, plan fiduciaries have not been afforded this same relief. In other words, benefit committees should still be continuing to meet regularly to monitor their benefit plans. Another CARES Act item here in the second bullet point that's specific to defined benefit pension plans. And as Jen mentioned up front, I am a retirement actuary, so primarily dwell in the world of defined benefit pension plans, is that contribution due dates that would otherwise been sometime during calendar year 2020, those have all been delayed until January 1st, 2021. However, January 1st, 2021, which is what is written in the statute, is a bank holiday. And so we generally, in the pension plan world, if a due date falls on a bank holiday, the requirement is to make the cash contribution on before the bank holiday. So that date would be December 31st of 2020 or before that. So now I'll turn it over to Brian and he'll cover the rest of the bullets on this slide.
Thanks, Carl. So the next bullet is very straightforward. There still is no relief for employers for making their profit sharing contributions to the plan. So those are still going to be due when they would normally be due. With respect to employee contributions and amounts that the participant's going to repay back to pay back a plan loan, or amounts that have been withheld from their wages for their own employee elective deferrals, those generally have to be forwarded to the plan's trust on the earliest date that they can be aggregated from the general assets of the sponsor. And that rule does not change. So you're still subject to the general fiduciary requirement to get those amounts into a plan as quickly as possible. Now, the DOL in EBSA Disaster Relief Notice 2020-01 did provide a little bit of relief in that they said that they're not going to take the DOL is not going to take any enforcement action against an employer if there's a delay in getting that amount into a plan, and the delay is solely due to the national emergency and COVID-19, and the employer otherwise acts as prudently as possible to get the amounts into the plan as soon as possible. So if you normally get your amounts into the plan, let's say in a two-day turnover period from when they're withheld from an employee's paycheck, and now you start having, let's say, a 4-day turnover for 1 or 2 payment periods, and that's due to some national emergency COVID-19 issue. Let's say that your office was shut down for a cleaning because somebody was diagnosed with COVID-19, and therefore the person responsible for making the transfers wasn't able to do it on the day that they normally would do it, and so there's a day or 2 delay. That's not going to be enforced by the DOL and put you through the corrections procedure. The next thing to discuss on this slide is the suspension of safe harbor contributions. Generally, if you have a safe harbor plan and you want to stop those safe harbor contributions in the middle of the year, you can do it. You can do it if you send out that safe harbor notice, and the notice says that you could do it, and you give them the 30-day notice period before you stop the safe harbor contributions. Also, you can do it if you're operating in an economic loss, which means that you have to not be turning a profit for that year generally. So if you did have a safe harbor notice and you wanted to suspend it, keep in mind the statement that's going to inform them of the potential reduction or suspension. It has to inform them that, 1, you can amend the plan during the plan year to reduce or suspend your safe harbor plan contributions, and 2, the amendment won't be effective until at least 30 days after you've given participants the notice. So make sure that your safe harbor notice did qualify with those requirements before you decide to terminate your contributions based on that basis. And that could require an additional plan amendment and also possibly another notice to participants as well. And now I'll turn it over to Kristin, who is going to discuss some important auditor considerations.
Thanks, Brian. So what are we going to be looking at from an audit standpoint? You probably guessed based on what you just heard, but some of the things that we wanted to point out are with loans and distributions. Of course, we're going to be making sure that those are still administered properly within the plan guidelines as well as the IRS guidelines. Loan repayments, as we just heard, could be impacted by all of this. Partial plan terminations, I touched on in the beginning. We're going to be seeing more of those as a result of various layoffs. So we'll be assisting clients in navigating through that, as well as ERISA attorneys like Brian. Additional disclosures and financial statements, of course, are going to follow with the COVID impacts. Timing and amount of employer contributions, like we just talked about, could be impacted, but still do need to be in compliance with plan provisions. And then we've got some more on the next slide. So timely employee contributions and loan repayments, Brian just talked about this. We're still going to continue to monitor this, and we'll advise if we see those outliers and make sure that you've got documentation on the plan sponsor side as to why those occurred, just in case there was an audit by the DOL. And we're going to be looking at internal controls like we always do, but there will be changes probably at the plan sponsor as well as the service provider level. So we'll be considering those on both sides of that. We're likely going to see new payment types and codes. So like we always do, we are going to closely monitor eligible compensation and assist our clients in trying to read their plan documents and interpret what those are trying to say and make sure that the appropriate compensation definition is being followed. And I know Brian deals with that a lot as well, so he's going to be assisting his clients with this. The main thing there is just to make sure that when you've got new payment codes in payroll, that those are being set up properly as eligible or ineligible wages, and just making sure that we're taking into account any impact of CARES and what changes that might have had on those. And then plan fees may increase as we see more of those expenses running through the plans. So I'm going to turn it back over to Brian to discuss some additional relief.
Thanks, Kristin. So some of the additional relief that's come out has been in the form of IRS notices and then the EBSA disaster relief notice. There were some Treasury regulations last year. I'm going to go through some of the relief that was granted. In Notice 2020-23 and Notice 2020-35, those both deal primarily with extending deadlines. So 2020-23 extended a lot of employee benefit related deadlines that would ordinarily have fell on or after April 1st of this year through July 14th of this year, extended those deadlines to July 15th of this year. So plan loan repayments, those were extended, and this delay under the notice applies to all participants, not just the qualified individuals who are otherwise eligible to receive coronavirus-related distributions and coronavirus loans. And then the timing of indirect loan rollovers, required minimum distribution payments, which would have otherwise had to have been made, which now don't have to be made, and distributions of excess deferrals, corrective distributions for excess contributions, to the extent that any of those needed to be made before July 15th, after April 1st and before July 15th, that deadline's extended to July 15th. In 2020-35, there was some additional extensions. Importantly, if your plan is going through the voluntary correction program component of EPCRS, and you received a compliance statement and the deadline to make all the corrections fell within April 1st through July 14th, you also have until July 15th to make those corrections. Also, Form 5330 for reporting and paying excise taxes, the filing and the associated excise taxes, that's also been changed. So the period from March 30th, 2020 through July 15th, 2020 is disregarded in the calculation of any interest or any penalty for failure to file. And then there's also an extension of the initial remedial amendment period for Section 403B plans. As you know, the initial remedial amendment period for making sure that your Section 403B plans were in complete compliance expired, but they've extended it from June 30th to June 30th, 2020. Originally, it was supposed to expire on March 31st. On spousal consent was addressed in IRS Notice 2020-42. Generally, to elect away from a qualified joint survivor annuity as a default form of benefit for married participants, or to elect a different beneficiary, you're required to get spousal consent. And the spousal consent, one of the requirements is that it has to be in person and witnessed by either a plan representative or notary public. And a lot of states have implemented e-notary provisions with the stay-at-home orders and the required social distancing. But the problem with some of the e-notarization is that you're not actually in the physical presence of the spouse who is signing the waiver. And that was actually not permitted because there's a physical presence requirement in the regulations. Notice 2020-42 provides temporary relief for that and permits remote notarization if certain safeguards are followed. And this is to accommodate, again, those local shutdowns and social distancing. 2020-50, I discussed a little bit before when we were talking about the CARES Act distributions, and Carl addressed some of the impact that it has on the loans as well. IRS Notice 2020-51, that extends the deadline to roll over what would have been RMD distributions that you receive until August 31st of 2020. So if you received, let's say, a distribution that was normally going to be a required minimum distribution for this year, and you received it earlier this year, and then the guidance came out as saying that the tax treatment is going to change such that it's no longer an RMD that's ineligible for rollover, but now it's eligible for rollover. Normally, you would have only had 60 days to roll over that amount into an IRA or another qualified plan. Now, instead, you can take that amount and you can roll it over, even if the 60-day deadline is expired, so long as you do it by August 31st of this year. And then the final regs, last year, they introduced a new safe harbor hardship withdrawal for expenses and losses incurred by an employee due to a disaster that's declared by FEMA. And I think now it's time for our first polling question.
All right, people are starting to vote. All right, we've got a good number of people that have voted, so we'll end the polling. And we'll share the results. Looks like answer A, COVID-related distributions, is the top choice.
Yeah, that seems to correlate, I think, with what Brian, Carl, and I have been discussing. There's obviously a lot that's changed with this and a lot of different options available that Brian's covered. So hopefully some good information, and we'll look for more to come. But thanks for supplying that insight for us. We're going to turn it to Carl next to discuss the Secure Act.
All right, so thanks, Kristin. I guess I'll start off with saying I think it is fair to say that the Secure Act has taken a back seat to all the other significant developments we've been experiencing since mid-March. But the Secure Act is a major piece of legislation with many considerations for plan sponsors. So first here, we're going to talk about the Secure Act with respect to defined contribution plans. So the first item we have is the RMD age change from 70.5 to 72. So this, I expect, has been and will be welcomed by many plan participants. So the change only does impact those participants who had not attained age 70.5 by December 31st of 2019. So for those participants who had not attained age 70.5 by December 31st of 2019, these participants' RMD dates will now be April 1st, following the year they turn age 72. So for example, for someone who was born in August of 1949, they will turn 70.5 in 2020. So that means they were not 70.5 before the end of 2019. So that means that their RMD date is the April 1st following the year they attain age 72. So someone born in August of 1949 attains age 72 in 2021, their first RMD date will be April 1 of 2022. And now this, of course, assumes that they are not actively employed. They're not an actively employed plan participant, because by and large, most defined contribution as well as defined benefit plans for actively employed participants, they don't require participants to start taking distributions while actively employed. So next, the RMD rules for non-spouse beneficiaries have changed significantly. Again, it gets fairly detailed, but briefly, prior to the Secure Act, non-spouse beneficiaries had the option to take payments from the deceased participant's account balance over the non-spouse beneficiary's lifetime, assuming the deceased participant had not reached their RMD age prior to death. Now, post-Secure Act, these payments have to be taken over a 10-year period. So the group of people that are going to be the biggest ones that feel this are going to be adult children. So adult children, rather than being able to take their parents' account balance and spread up the distributions over their lifetime, they'll now have to spread that over a 10-year period. All right, next item is qualified birth and adoption withdrawals. So while guidance is needed with respect to several of the details, in general, QBOADs, so that's qualified birth or adoption distributions, it's a mouthful. So QBOADs of up to $5,000 per participant for each birth or adoption are now allowed from the plan. And so I say per participant. So what that means is if you have, a couple that have a child, and both people work for the same employer and are participants in the same plan, each can take $5,000 from that plan for that single birth. So again, it's $5,000 per participant. The distribution is subject to optional 10% withholding, and it can be paid back to the plan, and that payback is without interest. But again, there's a lot of details and guidance that are still needed with respect to this. And then the other item about QBOADs is that this is an optional plan feature. It's not a requirement for plan sponsors to add to their plan. Next up, we have the new lifetime income disclosures. And so again, this is related to defined contribution plans. And this is a new requirement in the Secure Act that is there so that participants can understand how much of a monthly payment their account balance could buy. So the requirement is that this participant disclosure will be required to be provided once every 12 months. And the first time it's going to be required is no more than 1 year after we receive all the necessary guidance in order to provide the notice. And then lastly on here, we have non-discrimination testing relief. So some defined contribution plans offer larger benefits to a closed group of participants. So you could think of it as, Group A gets an 8% match and everyone else gets a 6% match. And there's often history behind why that is the case. Why does Group A get that higher match? And that history often is because Group A was part of, say, a richer retirement program in the past. And then the employer, the plan sponsor, decided to reduce benefits moving forward, but wanted to grandfather in a certain group of participants. So when that type of plan change is made, it often can result in non-discrimination testing problems because that group of participants that is getting that larger benefit, it often becomes disproportionately highly compensated over time. And so pre-Secure Act, the way the rules work is that that group would generally start failing non-discrimination tests, and ultimately that group would no longer be able to receive those larger benefit levels. But what the Secure Act has done is that for plans that are structured in this way, that have a grandfather group of participants receiving a larger benefit, so long as that plan has met a few criteria, that plan is then exempt from certain non-discrimination tests moving forward. So that plan, that grandfather group will be able to continue to receive that 8% match, for example, in the future and not have to worry about failing certain non-discrimination tests. All right. So I'll turn it over to Brian, who will take care of the next page for us.
And before we move on to the next slide, I just wanted to add a little bit more on the eligible designated beneficiary, this change in the rule. Like Carl said, it's primarily going to impact adult children of the participant because they're going to be limited to the 10-year rule where they can only take the benefit over 10 years. It's a little bit tricky when you're including this into your plan document and figuring out how you're going to structure it because for minor children, they're allowed to continue to take it over the lifetime, but then no longer than 10 years after they reach the age of majority, which for this purpose is 21. And then there are a few other categories of people who get grandfathered in as being eligible designated beneficiaries, and those are going to be anybody who's not more than 10 years younger than the participant, who's disabled or chronically ill. So then the question is, well, what constitutes chronically ill or disabled for purposes of implementing these timing provisions? And that there isn't any guidance that is specifically structured how you would need to determine that if you were the plan administrator. So there are a lot of considerations that you're going to have to take into account when you're amending your plan to comply with the requirements of the Secure Act. So moving on to the next slide. Here's 4 other big issues coming out of the Secure Act for defined contribution plans. The first one is the change to the qualified automatic contribution arrangement, the auto enrollment provisions. So currently the way it stands, or currently I should say pre-Secure Act, the way it stood is that, if you're going to introduce a QACA, the minimum default amount had to be at least 3% of compensation for the first year, and then 4% for the second year, 5% for the third year, 6% for the fourth and all subsequent years. That did not change. So the floor, the minimums remain the same. What did change is that before the Secure Act, the maximum amount that you could escalate to was 10%. And now that amount it still remains at 10% for the first year, but it can go up to 15% for second and all subsequent years. So you can expand it to allow for increased growth through the automatic escalator provision in your QACA. There's a new safe harbor for guaranteed retirement income contracts. It's a new Section 404E in ERISA, and this allows for the prudent selection of guaranteed retirement income contracts on behalf of an individual account plan. In addition, on the same topic of lifetime income, there's actually a new disclosure requirement that's going to go into effect. As you know, as a plan sponsor, Section 105 of ERISA requires the administrator to provide at least annually to all participants notices, and it's actually quarterly if you allow for participant-directed investment. And these statements have to include certain information on them. There's a new piece of information that's going to have to be included every year, and that is the participants' total accrued benefit in their account balance translated over into a lifetime income stream. So even if you don't allow for any sort of annuity product in your 401k plan, you're still going to have to show them what their benefit would be if they decided to convert it to an annuity when they take their distribution. And this is going to go into effect in the future. It's not effective right away, and it's going to go into effect with respect to any statements that are issued more than 12 months following the latest of one of the following, the DOL of the latest of the following, which is the DOL's issuance of interim final rules, the DOL's issuance of a model income disclosure, and the DOL's issuance of the assumptions that are going to have to be used to convert the total accrued benefits to a lifetime income stream. The DOL has not issued that guidance yet, but once they issue that guidance, then you'll have 12 months to get out your first statement to participants that includes that information, and then you have to do it at least once a year thereafter. The next issue that came up with the Secure Act is relating to long-term part-time employees. Plans are currently permitted to have a general service exclusion for employees who have not yet completed 1 year of service with a minimum of 1,000 hours of service. So in that case, if you have this 1,000 hours of service requirement, your part-time employees really have a limited opportunity to get into the plan and participate. The change is now, if you have a 401k plan, you have that service requirement, you still have to let in employees who have at least 500 hours of service over 3 consecutive 12-month periods, and who have also attained age 21. And what do you have to do? You have to allow them to make elective deferrals under the plan. You do not have to make them eligible for any sort of employer contributions. So when you have to make them eligible, it has to be the first day of the first plan year after these eligibility requirements are satisfied, or 6 months after the eligibility requirements are satisfied if that happens earlier. So what does this mean for employers? Well, for starters, most employers may not have been, or many employers may not have been tracking the hours, exactly how many hours these part-time employees have had if they're below 1,000 for purposes of the requirement. But going forward, starting next year, you'll have to start tracking whether they top the 500-hour requirement or not. So for in all respects, this really won't go into effect until 3 years have passed starting from next year, because that's going to be the first year of the 500-hour requirement for purposes of determining whether these participants are eligible. And these employees are going to have to receive also a year of vesting service if they're credited with at least 500 hours of service in the applicable 12-month period. The next, and just another note on that is that this isn't going to apply to collectively bargained employees. This only applies to non-union employees. And then the next one is this elimination of the safe harbor notice requirement. Now, this only applies to safe harbor notice requirements for plans that have a safe harbor contribution, not a safe harbor match. The plan administrators still have to continue to provide their employees with the opportunity to change their deferrals at least once per plan year. And now with this elimination of the notice requirement, plan sponsors are actually allowed to switch over to a safe harbor 401k plan with non-elective contributions prior to the 30th day before the end of the plan year. But if they, instead of doing a 3%, if they do at least a 4% non-elective contribution, you can actually amend your plan to switch over to be a safe harbor anytime prior to the last day of the following plan year. So you get this extended period for which you can retroactively amend your plan to be a safe harbor plan as long as you're giving a 4% contribution. So I think, Carl, would you like to discuss some issues relating to pooled employer plans?
Yes, we'll do. And I'll probably run through this a little faster than I would have otherwise liked in the interest of time. As you can see, there's a bit on this page, but we'll start off just with, the multiple employer plan, or MEP, or what I'll call MEP. I think we all know that's been around for a long time, but certain limitations and risk have prevented, wide adoption by plan sponsors. So a few of these limitations and risk are that they only allow related employers to join forces. A failure by one participating employer could cause problems for the other participating employers, and that in general it didn't limit the employer's fiduciary role or risk. So the Secure Act has alleviated these limitations for the most part through the creation of the Pooled Employer Plan, or PEP, or what I'll call PEP. So unrelated plan sponsors are allowed to join the same plan. Failures by one participating employer do not taint the other participating employers. And the fiduciary risk has largely been eliminated for participating employers. The fiduciary risk now is expected to be largely limited to just the selection of the PEP plan provider or plan administrator. So what are some other benefits to employers in addition to what I've already mentioned? It also frees up time and resources for the plan sponsor to focus on their core business. The only responsibilities that the employer or plan sponsor would have is limited to selecting the PEP provider, setting the level and design of DC contributions, and then sending the payroll file to the PEP record keeper. Another benefit for employers is that this is just a consolidated and standardized process to managing the plan. So it's really going to simplify items for the employer. And then if we look at the employee, what are the benefits for employees? So the expectation is that there'll be lower fees for employees, and that there'll be the adoption of best practices such as lifetime income and target date fund innovation. So the Secure Act opens up the PEP option effective January 1, 2021. So I'm sure you've heard some about PEPs, and you'll likely be hearing more and more in the coming months and years as we expect these to take off. So with that, I'll turn it back to Jen for polling question number 2.
All right. And here's the question: considering the possibility of switching to a PEP? Lots of people are saying no. All right, we're going to go ahead and end the polling here. Sharing the results. Far and away, no.
Right. And so in that, I expected something very similar to that. And as with anything new, and especially, new and I guess so far away from what we're used to, it is going to take time for people to get used to this new option. And most plan sponsors will want to learn from the experience of others before joining themselves. All right, so Jen, I'll go ahead and flip to the next page. Mm-hmm. And so here we're just going to talk real briefly about defined benefit considerations with respect to the Secure Act. So I'd already mentioned non-discrimination testing relief for defined contribution plans. Well, that same non-discrimination testing relief has been provided for pension plans that have the same type of grandfathered group. So I won't go into any more detail on that. Next, required minimum distribution age, just like we saw for the DC plans, it has been increased from 70.5 to 72 for DB plans. The one interesting thing to note here, though, is that for participants or active employees in a defined benefit plan who continue to work past age 70.5, pre-Secure Act, they would get actual increases on the benefit that they're accruing post age 70.5. And post-Secure Act, while the required minimum distribution age has changed to 72, the age at which these actual increases kick in for employees who work past 70.5 has remained 70.5. So that's a nuance that I think plan sponsors need to be aware of, and then it will influence other decisions related to how the RMD age of 70.5 and 72 is implemented and how plan documents are amended. The next item here, we see the minimum permissible age for in-service distributions has been lowered from 62 to 59.5. So this is just allowing plan sponsors to provide, to give employees the ability to access their retirement money in their defined benefit plan to the extent that they want to encourage some sort of phased retirement. So employees would be able to supplement, say, lower wages because they're working reduced hours by getting access to their defined benefit pension plan while continuing to work. And so we have never seen much of an uptake when the in-service distribution was lowered from age 65, well, from normal retirement age to age 62 back with PPA in 2008. So at this time, we're not expecting to see a large uptake in the change from 62 to 59.5. And then lastly, on this page, we just wanted to mention that while not technically part of the Secure Act, but part of the legislation that was passed at the same time as the Secure Act, there was the repeal of 3 Affordable Care Act taxes. So the big one here you'll see is the 40% excise tax on high cost plans. So this is the big item for both active healthcare plans as well as retiree medical plans. So with that, I'll turn it over to Kristin.
Thanks, Carl. We want to be respectful of your time. We're throwing a lot at you in an hour, so I am not going to go over everything on this slide. You can take a look at it later. It just basically reiterates from an auditor perspective the kinds of things that we're going to be looking at as it relates to what Brian and Carl have just touched on for a Secure Act. So I'm going to turn it back to Jen to close us out.
Great. Thanks, everybody. Kristin, Brian, Carl, that was a lot of really great information. You'll note that their contact information is on screen. So if you have specific questions about what they went over, please do so. Reach out to them. They're more than happy to answer your questions. CPE certificates are going to be sent via email to all the attendees within 2 weeks. If you're an HR professional, the certificate that you receive can be submitted for your continuing education credits. Additionally, the recording of the webinar will be posted to the PKF Texas YouTube channel at sometime in the future. We're not quite sure when that'll be posted yet, but it will be up there. Please be advised that watching the recording will not qualify you for CPE. You had to attend live. And then when this webinar ends, you'll receive a pop-up link to an evaluation. Please take a few minutes to provide your feedback, as well as share any additional topics you'd like us to cover in future sessions. Your feedback is valuable and it really helps us to design future seminars. The link to the evaluation, as well as a copy of the presentation, will be provided in a follow-up email tomorrow that'll come directly from the Zoom system. So with that, Kristin, Brian, Carl, thank you again. Everyone who's attending this, thank you. We appreciate you spending some time with us today, and have a great rest of your day.
Thank you. Bye-bye.
Thank you.
Thanks.
Thank you for watching this recording of our Zoom webinar. A quick reminder that watching this video will not qualify you for CPE credit. For more information about PKF Texas's upcoming webinars, contact Jay Lemansky at pkftexas.com and stay tuned for future topics.